Okay, we are continuing. Now we go in English. Our colleague, who is the Legal Policy Director of the Rape Crisis Network Ireland, Counihan, is with us. And she will speak about consent in Irish criminal law, many positive developments and what should be done next. And also it's about introduction of a definition of consent and ratification of Istanbul Convention. It will be also discussed about how historic child sexual violence is investigated and prosecuted. Yeah. And also there will be an overview by Rape Crisis Network Ireland, current legal projects, as well as speaking about the in the context of coronavirus pandemic. So I'm very grateful for Caroline to be here with us, and for Rape Crisis Network Ireland to be a very active member of European Women's Network Against Sexual Violence. So thank you very much, and I give you the floor now.
Thank you very much, Dushika and Maya and everyone. And it is a great pleasure and an honor to be here to present at the Association SOS Helpline and European Women's Network Against Sexual Violence two-day international meeting. I'm going to begin by taking you through the recent changes to the Irish law on consent to sexual activity, which have happened in 2017. And I'm going to tell you not only about the law, but to the best of my knowledge, how it has worked in practice. And I have no difficulty about my slides being shared after the meeting. You're very welcome to have them. So don't feel that you have to race to take anything down in longhand or that you have to record anything. You're very welcome to have the slides. Now, a question which came up in our exchange of emails was, does our law on consent to sexual activity conform to the only yes means yes model in practice? And the question can be answered in the classic Irish way. It's a straightforward yes and no. So yes in some ways and no in others. Now, our criminal law on sexual offences is all about consent, or rather, there is no offence committed unless there is lack of consent, provided that the person giving the consent is an adult who has got the full capacity to consent. So, Irish law since 2017 defines our consent positively. A person consents to a sexual act if she or he freely and voluntarily agrees to engage in that act. And that is all. There is no need to show resistance by word or deed. There is no need for any violence to be above a certain threshold. It is simply the absence of consent, the lack of consent, which turns an otherwise consensual act into a crime. Now, it's also interesting that our law does not stop at simply defining consent. It also lists the situations in which there is no consent. And I'm actually the happiest about the very last bullet point on this slide, which makes it clear that in our legislation, consent is not given once for all time or for every stage of the sexual activity. Consent once given can be taken back at any time before or during the sexual act. And also, and it's fair to say that this has been the law for quite a long time, for 30 years in fact, failure to resist does not mean that there was consent. Failure to resist, as we all know, from dealing with survivors of sexual violence, is a very common reaction when people are being attacked and when they are terrified. It's often called a freeze reaction. People are so frightened that they literally can say and do nothing. And many years ago, it used to be put forward as an argument for the defense in a criminal court that if a person failed to resist, of course, that meant almost automatically that they were consenting, or that at any rate, they were not really objecting. And since 1991, in fact, our law has said that failure to resist is not the same as consent. And you cannot imply from a failure to resist that there is consent. So now I take you on to our next slide, which is the list of situations in which there is no consent. Now, they are, I think, a useful list because they take into account many very commonplace situations. For instance, little c, he or she, there is no consent if a person is incapable of consenting because of alcohol or some other drug. B, I'm sorry to tell you, is very common that sexual assaults and rape happen when a person is asleep or unconscious. And A is about force, that is violence or the threat of violence being applied, interestingly, not only to the person themselves, but to some other person. And the others are to do with mistake, including mistaken identity. They're to do with a physical inability, perhaps through a speech impediment or a failure to understand enough to be able to react in time because of perhaps a hearing impediment, something like that. Which in any situation where somebody is prevented from giving consent, from communicating, not so much giving consent, but from whether expressing whether they do agree or not. And there are a couple of interesting ones at the end. There is no consent in any situation where somebody is being unlawfully detained against their will at the time at which the act takes place. And finally, there is no consent if the consent, supposed consent, comes from a person other than the person to whom the sexual activity which is unwanted, is being done. So that's quite a big mouthful. It's quite a lot to take in. And this is, in effect, it's a kind of coming together of principles which have evolved over years in several different cases. And I'm happy to tell you that this list is also pretty much all of the same list that years ago, actually originally in 2008, Rape Crisis Network Ireland proposed to them. But I haven't actually told you one of the most important aspects of this law of consent is that this list, which I've just shown you, here it is, quite long. It's not a closed list, it's an open list. So it is open to a prosecutor to explain to the court that there was no consent, in fact, from the person for reasons that are not on that list. It can be argued, and the law explicitly says so. And if I dare say so, that was something which I suggested to them. And now I was not the only one. I don't like to take the sole credit for it, but I'm very glad that that is in there. And you may say, well, that looks like a very comprehensive list. Surely that covers most situations. And the short answer is, yes, it does cover most situations. But I give you an example. To the best of my knowledge, this has not been argued. But imagine that the person who is at risk of sexual violence is a vulnerable tenant who is being harassed by her landlord for rent which she cannot pay, perhaps because she has lost her job or something like that. And he comes to her and he says, I will let you off the rent and I will stay, you can stay in the house and I will take no measures to evict you as long as you sleep with me, say once or twice or whatever. Would there be consent in that situation? Is that consent which is freely and voluntarily given? I think it is at least arguable that it is not. And I'm sad to tell you that that has actually happened. We have heard reports of that happening. So it would depend a little bit on the circumstances, but if the circumstances were extreme enough, I think that argument might well succeed, but they would need to be very extreme. The person would need to be vulnerable enough to have really no other prospect of a home or indeed a roof over her head for the night. And sadly, there are people in that situation. And I think at those extremes, that's an argument that could run. So, if you like, consent then is not fixed, but at least potentially dynamic or moving. It has these examples, these situations, but they are by no means a closed list. And what I have noticed since the law has come in 2017, it has had a positive effect outside, I would say, the courtroom. And I've explained here, I've given the examples of education about consent. And what I'm referring to is rape crisis staff going into secondary school, sometimes third level, and explaining about consent and explaining what the law is. And explaining in particular that if a person is drunk, doesn't matter whether they were made drunk themselves, made themselves drunk, or they were intoxicated by somebody else without their knowing, it doesn't matter. There will still not be consent in the situation where somebody is so much under the influence of alcohol that they cannot consent. And they find that very liberating. They hadn't really thought about it. And the other one that really resonates with them is the fact that in law, it's actually written down that consent, once it's given, can be withdrawn at any stage before or during the activity. Because there's a kind of popular myth out there that once you give consent, that's it. You kind of give consent and you're committed, as if you had signed a contract. You have to go through with it. You have to fulfill the contract. But no, consent is not the same as a contract about money or land or some job that has got to be performed. It's completely different. It's subjective. And the idea is to put the power back in the hands of the person, that they have complete autonomy. At any stage, they can say, no, enough, that's it, stop. And the law will uphold them. I think that is... we will see more, how shall I say, we will see more of the effects of that as time goes by. But even now, I know that a lot of people listening to that message find it very liberating and very reassuring. Okay, and also something similar happens in the counselling room, where people sadly have already been the victims of sexual assault or rape. And the counsellor quite often will explain to them, you know, the criminal law is completely behind you now. What you did was not unreasonable. And as part of their recovery, having the criminal law explained to them, or being referred to me, because part of my role is giving legal advice in this situation, or legal information at least, or they may be referred from the counselling room to an appointment with a member of An Garda Síochána, our police force. And that for them is very much part of their recovery. So, I mean, these are green shoots. I'm not talking about a total transformation and the total abolition of the unfortunate rape myths which still dominate, but I am saying that more and more people are feeling empowered and that they are able to question these rape myths, which are so pervasive. And I think one of the worst rape myths is that once you give consent to anything, that's it, you're committed. You went home with him, you had the coffee, you had the drink, and that's it. You have to just go through with it now. And the criminal law says that's not actually the case. Now, and has this led, you may wonder, has this led to a huge increase in people reporting sexual violence? Numbers of survivors reporting to the Gardaí, that is our police force, have increased since 2017, but it's fair also to say that there are other factors affecting those numbers, such as more and better specialisation and training for members of An Garda Síochána. But we'll get on to that at the end. But I just wanted to talk about consent for a little while, so that you can see how it's constructed. Now, of course, this new statute, how shall I say, it came in, as it were, it was layered on top then of the existing law governing rape, defining rape, and in some ways it has led to a kind of a clash, but there's going to be a resolution of that, and I'm going to show you now in the next couple of slides. Now, you see, we have on the statute books an offence of rape. Now, this is strictly traditional man and woman, vaginal rape by penis only. And I've included the words of the statute, but in essence what they mean is that there is the element of lack of consent, but also it is enough, though it doesn't say this here, but trust me, it is enough if the defendant, the person who is accused of the crime, says that he had an honest belief that the other person was consenting. That is enough, regardless of how reasonable or unreasonable that belief is. Strictly speaking, all he has to do is say, I have an honest belief. And then once he has an honest belief that the other person is consenting, that is a defense. In other words, if the jury accepts that, well, then he's not guilty of rape. So we feel that this is a very bad fit with a whole law defining consent, which is centered, if you like, on giving power and autonomy to the person at the receiving end of the sexual activity, the person who has to make a decision whether to consent or not. And what we would like to see is that any belief in consent must be not only subjectively honest. I really do believe this, even though it's completely unreasonable or might seem unreasonable to others. That's not it. We want that to be not enough. A belief must be not only honest, but honest and reasonable. And I'm happy to tell you that our Law Reform Commission agrees with us and with others who've recommended the same thing. And we really need to change the law so that the belief is reasonable as well as honest. Now, it is fair to say that the courts can take into account the presence or absence of reasonable grounds. In other words, in essence, the surrounding circumstances, the reasonable grounds for that belief. So the jury can look to all the circumstances. But I would say that that's quite weak, because all the jury has got to do is consider these things. The jury does not have to really make a decision on that basis. The real issue that has to be decided is whether the belief is honest or not, and we say that's not enough. So let's just say that's work in progress. We've been advocating for this objective formulation of belief in consent, for a very long time. But now that the Law Reform Commission has finally decided that it agrees with us, I'm very hopeful that we'll have new legislation in this area in the near future. So there you go. Now, another thing I was asked to talk about was historic child sexual violence. And I should have said historic here, really. And just to be clear, in this slide, I'm talking about essentially child sexual violence, which an adult is now reporting to the police or reporting to their rape crisis counsellor years, or sometimes indeed quite often decades after it has happened. And I was asked to talk about any statute of limitations. And in Ireland, there is absolutely no general statute of limitations applying in all criminal proceedings. Excuse me, and that would include historic sexual offences committed against children. However, you can imagine, I suppose the first thing to say is really that these investigations and prosecutions are challenging. In other words, difficult for investigators and prosecutors, obviously because of the lapse of time, witnesses' memories becoming fainter. Of course, there's rarely any forensic evidence. There's rarely corroboration. Corroboration is, independent evidence that something happened. And independent in that context means independent of the complaint, of the victim's own evidence. Something completely different. It could be an independent witness, it could be forensic evidence, it could be something material. There's a range of things it could be, but of course, with the lapse of time, it's highly unlikely that there will be any corroboration, which of course makes the case a little bit weaker. It's great that these ancient offences can be prosecuted, in my view, because, if you like, there are safeguards there for accused people. If there is something which will really prevent the accused person from getting a fair trial, for instance, the death or the unavoidable absence forever, maybe through illness, of a critical witness, he or she can apply to the High Court to get the proceedings stopped. But on the other side, the side of the victim, I mean, our own clients are, about 60% adults who are reporting historic child sexual abuse to us of various kinds, various intervals, mostly 20 years and more in the past. And, you know, what has happened is, very sadly, their whole lives have been disrupted and spoiled quite often by this terrible experience when they were children. And it has taken them a long time to get to the point, perhaps where they can even tell anybody else about it, let alone go through the quite intensive and demanding process of individual counselling to kind of really start a proper recovery. And as part of that recovery, they quite often decide that they will, about 40% of them, no, maybe less, 35-40% of them will decide to report to the police, which is good. So for them, it means it's really helpful that they still can do that, because it's a way of saying to not just the abuser, but to the system, to the world at large, look, this happened to me. Maybe the case will not get to court. Maybe it will be dropped because it's not strong enough, whatever. nevertheless, I have had my opportunity to be heard and for my case to be considered seriously. And I have to say, I have to commend our Gardaí, our police, for working very hard to do their level best to get as many of these cases to court as possible. Now, I wish I could tell you that there were statistics available from Ireland, from our Director of Public Prosecutions or from our court service to separate out the historic sexual offences from the recent sexual offences which are prosecuted, but unfortunately they don't actually do that right now. They don't separate the historic from the recent sexual violence. However, the good news is the Central Statistics Office has begun to analyse the data that it holds, but they record only crimes recorded by An Garda Síochána, and these particular stats, to the best of my knowledge, they don't get into numbers of prosecutions. They just count everything which was recorded by An Garda Síochána when it was reported to them by the victims. So what we can see, and apparently having looked at the data, I can tell you that the stats really haven't moved much over the previous 3 years. Just under 25% of sexual violence victims reported offences which had happened 10 or more years before. And in our own network, we're hoping soon that we will be able to analyse the data we have to see how many of these historic child sexual offences are resulting in somebody making a report to An Garda Síochána among our own clients. But unfortunately, we can't tell you that yet, but that again is a work in progress. So that's child sexual violence. Nobody pretends it's easy. But having said that, there has been such a volume of these cases that I think what has happened over time, over the last 10 or more years, as more and more survivors have felt empowered to disclose the violence, to go and get help, to maybe report to An Garda Síochána, to tell their family about it. I think a certain expertise has developed, and if there's any chance of a prosecution, they really, in my experience, they really don't miss it. And the DPP also takes a very thorough look at each of these cases. And it seems to me, now this is purely anecdotal, but I have been in my job 12 years, that she's now perhaps less conservative than she used to be. It seems to me anecdotally, again, we don't have these figures, that she is prosecuting more of these historic cases and getting convictions on them before. Now, because she sets herself very high standards, if she decides to take a case to court, it has a very good chance of resulting in a conviction for something. Maybe not the most serious offence, sexual offence on the docket, but very likely some other offence. There will be. So it's over 2/3 probability of a conviction. So that's kind of the encouraging side of it. Now, the Istanbul Convention, oh gosh, every time I look at it, I remember how long it is and also how wide it is. In other words, how many areas it covers. We ratified it in March of last year, 2019. It entered into force in July of 2019. And broadly speaking, just to summarize it all, I would really say that our Irish government has been quite good at all the legislative aspects. It has gone a long way to cover all the bases, and this is mostly about sexual violence, because that's where I do most of my work. But as it happens, I work also a little bit for another organisation, Safe Ireland in Ireland, who are our sister network. Their particular responsibility is domestic violence committed against women and children. So I've worked on it a little bit from that point of view. And certainly on the domestic violence front as well, also the Irish government has been very good at covering everything that's an article in the Istanbul Convention. Where there is more work to do is in provision of services, I think, really. I think we have certainly got a very good framework. We've made a great start, but there is more to be done. And in particular, I would take you here to Article 26, Protection and Support for Child Witnesses. Now, the two aspects here, the legislative measures and the other measures. The legislative measures, there has been huge movement. When I get on to the more positive developments, I'll go into them. There has been huge movement in that area. However, when it comes to the services, age-appropriate psychosocial counselling for child witnesses, there is still nothing like enough provision. And there is one NGO who is partly funded by the government to provide specialist counselling to child victims of sexual violence, and they are absolutely inundated. We need much more in this area. We really, really do. The state provision, with a couple of exceptions, to services, both based in Dublin, to my knowledge, really is not adequate, in that it's not, that there's very little specialization in it. There needs to be a much more focused and holistic and specialist approach taken to sexual violence committed against young people. So that's where, if you like, to my mind, we have more to do. We are definitely, I think, behind. But saying that, I certainly think the will is there in the current government to ensure that what we end up with is a holistic suite of supports to basically support a young person, or indeed another victim who's an adult, in every aspect in which they need help. Now, Article 36, we've pretty well done. We've done all of that. I don't think there's anything that's missing there. Article 25, support for victims of sexual violence. Our network comprises 7 rape crisis centres. There are another 9 around the country. And there are a couple of other non-rape crisis specialist services, the one for children, which I already mentioned, and one which has a particular focus on adults who are survivors of historic child sexual abuse. And we are all incredibly busy. So I think many more resources need to go into rape crisis centres and other specialist services. And also there needs to be more of them so that people don't have to travel too far. And what it's all about is a timely intervention, that at the point when somebody needs a specialist intervention, particularly specialist counselling, he or she is able to access it. That's vitally important. So now this slide is a bit of a mixed bag. Sexual harassment, we'll go into that. We have got some provisions in our civil law already which do attack that, and we have a criminal offence of harassment. Sexual harassment may or may not, depending on the circumstances, fall within that definition. However, the good news is we're about to update the law in that area. I'll come on to that. So that too is a work in progress. Aggravating circumstances, yes, the fact of an intimate relationship, or whether it's a current intimate relationship or a former intimate relationship may be regarded as in fact should be regarded as an aggravating circumstance for a range of sexual offences and domestic violence offences. And thankfully, the law is quite widely drafted as to the nature of the offence. However, it is not all that widely drafted with regard to sexual offences. Only a certain number of sexual offences, and it's quite narrow in that it refers only to intimate relationships, which can be former intimate relationships, so that assaults which happen in a domestic violence context, which are a parent against a child or a child against a parent, would not be covered by that. But certainly aggravating circumstances, unless the circumstances are exceptional, should be regarded. Intimate relationships should now be regarded as an aggravating circumstance unless they're exceptional circumstance. That's good. Now, prohibition of mandatory alternative dispute resolution processes. Right. Where to start with this one? Well, now, if it's a criminal matter, really, it's hard to imagine a way in our system in which alternative dispute resolution could come in, unless it's by way of what they call restorative justice. Now, that hardly anybody and nobody who's really serious about it and about its effects on the victim would suggest restorative justice for a sexual offence in any situation where the person responsible had not been already convicted by a criminal court. Restorative justice could, and very rarely does happen, but only post-conviction when you're dealing with a sexual offence. I haven't heard of it happening in any case of domestic violence in Ireland post-conviction. No. And it's fair also to say that our law, the civil law, which deals with mediation in family cases, says that an application for a protection order or any other domestic violence order, a barring order, something like that, cannot be replaced or cannot be resolved by use of alternative dispute resolution. I think that's a good thing. But the trend is very much towards using alternative dispute resolution in family law in any situation which is not a domestic violence application and which is not a case of child protection authorities looking to have the children taken away, put into a foster situation or taken into care more generally. So, but the trend is to encourage alternative dispute resolution, say when it's a question of resolving with whom the child should live or anything like that. And we would be concerned that it would be hard to avoid at least some attempt at alternative dispute resolution in a case in which there was family violence very much as part of the background. And you may say, why isn't it better to do that than to drag everybody to the court? And I can just say, I don't say that lightly, but I have seen how abusive partners and fathers can absolutely make a meal out of, well, can abuse the system, the mediation process, so that it becomes all about them and about what they want. So it's something to be used, in my opinion, very infrequently where there's any question of a background of family violence of any kind. There you go. So we do have a version of emergency barring orders, and we have taken some, and we always had restraining or protection orders. Our emergency barring orders, they only last for 8 days. They're not great. Like, you know, we would love to see them last for much longer. But when I was working for Safe Ireland on this, we were told in no uncertain terms that there were very serious constitutional issues because of the Constitution, our Irish Constitution. The rights of property owners are very, very strong. So there certainly the law up to now would only would not allow for somebody on an emergency or interim basis to be put out of their home for longer than 8 days. Yes, somebody can be put out of their home, to be clear, but only after a full hearing. And as I say, never on an emergency basis for longer than 8 days, unless and until it's proven that there's an immediate and serious risk. And that applies only to what are called interim barring orders, not to emergency barring orders. Emergency barring orders are useful in that they can be applied for by people who have no legal right to live in the property, which is not the case with ordinary barring orders, but they do last only for 8 days, though you can, after an interval of a month, you can apply for a second emergency barring order if you want. So it's reasonably restrictive, but at least it's there, and something we won't be leaving alone, I can assure you, not at Safe Ireland anyhow. So measures of protection, we've certainly done a lot on that. I'll come on to that. Custody, visitation rights and safety, you see, this Article 31 exactly gets what I was just talking about. Incidents of violence are certainly taken into account, don't get me wrong, when it comes to deciding issues of custody and visitation. But with great respect to our legislators and our judges, I don't think family violence is given nearly as much weight or as much importance as it should, really. The rights and safety of the victim or any children are kind of, I won't say put aside, they're not put aside, but there's a feeling that they must always be balanced with the right of the child to have access to both parents. So the tendency of the courts is to make some provision for access by a difficult or abusive parent to the children in just about any situation, but they may put conditions on it. It must be supervised. It can only happen in this place, not in that place. It might be quite short. But there's almost an idea out there that some access must be given. And personally, I think there are some family situations so abusive that it is really an abuse of the children for the courts to insist on access. Now, thankfully, as time has gone on, our judges have gained a much greater understanding of the dynamics of sexual and domestic violence within the family. I think that happens less often now, but I still think even in our legislation we could attach more weight to the rights and safety of the victim or children. So, yeah, psychological violence, Article 33. Well, yes, we can check that box, I think. Yes, we have got an offence of coercive control, and I'm happy to tell you that we have had a couple of convictions, and most recently a conviction after a not guilty plea, in other words, after a long trial. Stalking, we're working on that. We do have, as I say, a criminal offence of harassment, which could be improved and is being improved, to be fair. We have an offence of forced marriage as well, which came in 2018. And I'm glad to see that, because in a previous life I was an immigration lawyer, and I could never actually prove that it had happened. But I so many times I had my suspicions, and I had plenty adult clients who told me they had been forced to marry somebody kind of against their will, and they kind of felt, I mean, this person that they were marrying would not have been their first choice, not by a long chalk, or even their 10th, but they felt that they absolutely had to, for economic, cultural, familial reasons, you know. So it's very difficult. And we've had an offence of female genital mutilation for quite a long time as well. So anyway, the latest perspective, there's been a couple of convictions in 2020, and the good news is there's something like 40 investigations ongoing at the moment, and there's a separate bundle of files in the Office of the Director of Public Prosecutions. It's also very good. So there's our police service, our Garda Síochána, has now got a specialist unit to look at investigations of sexual and domestic violence in every division, that is police division in the country, all 28 of them, which is absolutely marvellous to have that. So what I would say, having listened to clients, gosh, for 12 years, is that since this rollout has begun in 2017, it's happily now completed, the numbers of complaints against An Garda Síochána, or terrible stories which weren't complaints, nobody was making a formal complaint, but were shocking to hear, they have dwindled almost to vanishing point, and I'm getting many, many positive reports. And I think they've taken the key to it is the training. They've taken it absolutely seriously. I can certainly assure you of that. In the new Family Court Bill General Scheme is just jargon that means the first stage of the bill, the kind of grand plan for the bill, if you like. There would be no question of applications for protection orders, barring orders, emergency barring orders, anything like that, being resolved, as I was explaining earlier, under alternative dispute resolution. Now, very importantly, I've just given it one bullet point, but look at it's about, gosh, it's a couple of 100 pages of a report. The O'Malley Review of Protections for Vulnerable Witnesses in the Investigation and Prosecution of Sexual Offences was published after 2 years this summer, and its recommendations were the subject of an implementation plan, which was put together in consultation with the specialist support services and the legal professions, and informally also with the judges, the court service, and the Gardaí, the prosecutor's office. Everybody was involved in preparing an implementation plan. And we're happy to report that this implementation plan has now been developed, and it will focus on improving the experience of the victim of a sexual offence at every point, from the very moment of the offence, through forensic medical examination, if any, through seeking help from rape crisis, and through making a report to An Garda Síochána, through the process of investigation, and finally, if she's so fortunate that it is prosecuted, as far as court and beyond. So it's the aim is to cover the whole journey, and I absolutely must commend our current Minister for Justice. She has made this an absolute priority, and there's no doubt about it. She's moving ahead as fast as she can on all fronts, and also we NGOs are being asked to help out in subcommittees working on particular topics, to donate, if you like, our time. And well, I don't really see it as donating, because my post is government funded anyhow, but I mean, I think it's great. We're all working together. So anyway, sorry, have I gone on a bit too long? My apologies.
A little
And
bit, but you're so generous sharing. Yeah,
I'm so sorry. I'm so sorry.
You're very generously sharing experience, and that's why we didn't intervene earlier. But what is happening parallel is that there are many questions. So I will ask our audience as well to be a little bit more patient, and we shall prolong your part just for 5 or 6 minutes, please, from this moment on. And it will be difficult to answer all these questions in 5 or 6 minutes, but please try to be very brief, right to the point, if it is possible. So one of these questions, which is in a way also repeated, it is in which way police, court, and prosecutor's office are reacting on this model only yes means yes. And having in mind that in the states where it is still not introduced, they're very often saying that it is going to make much more difficult collecting evidence for them. So it is it is all the time repeated in these questions that come from chat, that everyone is saying that it is really very precious to learn from your experience. So could you please comment very briefly on this?
Well, how to say it? There's no doubt that it is hard for any prosecution to succeed because we have a high standard of proof. It must be, any criminal offence alleged must be proved beyond reasonable doubt. And proving the lack of consent, there's no doubt it is challenging. But what the new legislation has done has, if you like, it has opened it up and made it easier by tabulating it, by setting out the list of situations in which there is no consent, and by imposing, if you like, a clearer guideline, you know, and particularly that thing of you can withdraw consent at any moment before or during the act, and though that's actually quite myth busting. So it actually hasn't been as difficult as it was feared. In essence, this law is mostly only putting together what was there anyhow. But what helps is that now there's a clear statement, a guideline to which you can refer, if you like. So I don't think there's a perception that it's more challenging now. What is actually happening is that society is changing. The decision makers sitting on juries are changing, and they are less easy to persuade with old-fashioned rape myths than they were before. And I think that's where you see the true difference. This can only work if you have proper education and awareness on consent going on outside the courtroom. But at the same time, the fact that the criminal law says clearly this is the line, that really helps the culture to change. So the two things go together. That's really what I would say. Yeah.
Thank you. And I mean, I see that is very live on the chat, and it is all the time about yes means yes. In terms of, for instance, I will tell you a couple of comments and questions, and then you please summarize also your answer, if possible. It is that are there specialized prosecutors for sexual violence in Ireland? That's one.
Yes. Yes. Well, that is the unit. There's a specialist unit being set up in the Director of Public Prosecution's office right now, right this minute. Yes, but effectively, you see, specialization within the unit within the DPP's office had been growing anyhow. So now the DPP has made it a formal structure and created a unit specialized in sexual violence, which will deal only with that. I'm happy to tell you. So yeah, it's great. Yeah,
Okay.
I think that's actually key, because it's a specialist job prosecuting any form of sexual offense.
Yeah, yeah. Okay. And also someone is asking, what about the rights of rapists?
Oh, the rights of rapists are terribly well looked after in the Irish courts, and they have constitutional backing and everything. I mean, we start with Article 38, 38(1) of our Constitution, which, if you like, overrides everything. That every person is, in essence, every person is entitled to a trial in accordance with the law. And that has been interpreted, if you like, over the years, quite I won't say indulgently, but it's been regarded as the safeguard for anybody accused of a serious crime. I would say that their rights are robustly defended from the Constitution through the many aspects of the legislation, and also in court. Everybody who defends them will do that extremely robustly. There's no question about that. And also we have a line of Supreme Court cases which in essence say other people in the criminal justice process do have rights. Of course they do, and clearly now victims have enumerated rights in our courts. But if there comes to a conflict of rights between one person and another, the rights of the accused should always be regarded as paramount. So yes, I would say their position was pretty well protected, and without even beginning to get into the law of evidence, and really our rules on criminal evidence are very stringent, and our standard of proof is very high. Everything must be proved beyond reasonable doubt. All a defendant doesn't have to prove anything. All a defendant has got to show is a reasonable doubt, as opposed to prove anything. So yes, I would say the system was tilted still very much. It's not evenly balanced. It's tilted in favor of the accused person, definitely.
Okay. And one before the last one question.
Yeah.
It is about dilemmas that are very often on the side of prosecution office, that survivor was obliged still to show in some way that she didn't want it.
Yeah, I mean, the prosecutor, I'd put that slightly differently. The prosecutor has got to prove a lack of consent. But first of all, the list of situations in which there is no consent is a huge help. And even if your situation does not fall into any of those, in essence, what has to happen is that the complainant is first of all believed. I mean, her credibility is key, and her credibility is central. But what she says, of course, is evidence. And if she's believed, our law says that actually that can be enough. Now, it's rare that you get a conviction with just the word of the complainant and no other evidence, but it can happen. And I mean, we do get convictions even in those historic child sexual cases. So sometimes that is just enough. But I mean, more often the surrounding circumstances are used, as well as forensic evidence, as well as direct evidence. Sometimes, believe it or not, there are actually witnesses, not so much that see things, but hear things. Sometimes there's physical evidence. It's a question of looking at absolutely everything and being meticulous in case preparation, in investigation, that means, and going in there to make sure that evidence is preserved at an early stage, is seized and preserved, and that it is kept safely until trial, so that there can be no challenge to its authenticity. So it's about a rigorous approach, really, but it can be done, and it is being done. Yeah.
Okay. And the last one is, of course, maybe very general, but still I hope you can comment on it. And it is about your opinion, what must be changed in society so that such a law could be passed. And of course, one condition for it is political will, but what more?
Persistence. I mean, 2008, we put a checklist together, very like that list of situations in which there is no consent, and we started lobbying. And in the beginning, we didn't do too badly, but then other circumstances intervened. You may remember that was the time of the appalling crash that hit the whole world, not just Ireland. So the government at the time naturally had other priorities, you know, keeping us from bankruptcy and starvation being the two main ones, really. Then the history of that particular piece of legislation was then it kind of got snared up with various other bits. And people would then started saying, yes, but do we really need this? And it's about keeping it up and keeping it up on every level, talking to ministers, talking to government politicians, talking to opposition politicians, getting your message out in the media, taking every opportunity to influence the decision making, appearing at parliamentary committees, making submissions, and persuading, really, keeping it up and keeping up the pressure on all fronts, what I would say, really, yeah. And it did take a while. It took from 2008 to 2017 before it was finally enacted. Yeah, and there were several times when we thought, oh my goodness, this isn't going to get through. But I think really it was about saying to them, this is about setting a standard within the criminal law, and that in itself will have an effect on the culture. And I can't say we don't have attitudinal research now, but at this moment Ireland our Central Statistics Office is getting ready to do a prevalence study which will also look at attitudes. So if you ask me that question in 2024 or 25, I'll have a good idea. But just anecdotally, I can tell you people are feeling empowered, and more empowered than they were, and more inclined to push back against the rape myth culture than they were. And we can tell that from work that we do in education and work that we do in the counselling room. And we're aware also of survivors' movements and organisations coming to the fore, which they did not before the last few years. And I think it can be no coincidence. But it really is. This law is not just about what happens in the courtroom, it's about the whole of society, because when the whole of society gets to understand the real nature of consent, well then, at the end of the day, you're going to get jurors in the courtroom who are much better informed and much less likely to be taken in by rape myths. So that's really the answer, yeah, I think.
Thank you very much, Caroline. It was really a pleasure and privilege. It was enormously precious, I'm sure, for the audience. And what I again learned is that, of course, there is a lot of work to do, not only with the general public, but with professional public in particular. For all these internalized messages during upbringing and rape myths, and that there is still way to go. So thank you very much.
Thank you very much indeed, Dušica, for having me, and to Maya also, and to Nate for being so patient with my technological incompetence. It's been a very great pleasure. I only hope I haven't gone on so long that I queer your timetable for the rest of the day. But thank you very much for the privilege. I appreciate it. Yep.
It was very important. Thank you. Thank you.
Thank
I'll now switch to my native language. That is okay for you? Yeah.
Okay. Bye.
Bye.
Bye-bye. And is it all right to sign off now?
Yeah.
Okay. Okay. Thank you. Bye-bye.
Thank you.
Yeah.
Okay.